and alternative energy, whether it's turbines or solar farms. So I thought, who better than to ask Darcy Allen with the Farmers Advocate to come in and just kind of clean up some questions and give you guys some information. Before we leave tonight, at the back on the small table there is an evaluation. I'd like you guys to fill it out. That way I know what to do for the next events, if I'm doing okay with this one. And everybody has that special ticket still. We have a couple door prizes we'll do after we have some presentation and some question and answers. Darcy?
Evening, everyone. Just because in the back, you're sitting in the back doesn't mean you get to heckle. It doesn't give you the right to heckle. And if you do, you get to move to the front. Lots of information to go through tonight. Thanks for having the Farmers Advocate's office here. You have to let me know if this is too loud, too quiet, or if I need to move it around a bit. But capturing all of the aspects of renewable energy operations into a single session like this is absolutely impossible. So what I'll try to do tonight is just to keep my remarks to a high level, and that just helps hopefully to give you a little bit of information tonight, but also to encourage you to learn a little bit more about the industry and maybe about the aspects that you're faced with today. I need to point out right off the get-go as a disclaimer is the Farmers Advocate's office is neither in support of nor are we in opposition to any renewable energy operations. So our role here is really just to mention a few things tonight that we feel may be beneficial for you to take into consideration should somebody come and tap you on the shoulder and want to talk to you about hosting any renewable energy operations. So with that, like I said, lots to cover. So without further ado, how many of you are aware of or have dealt with the Farmers Advocate's office before? Just by way of show of hands. Okay, so a couple. So as a matter of introduction, just for those of you that aren't familiar with our office, is really the mission of the Farmers Advocate's office is really just to create value for rural Albertans, farmers and ranchers, and our rural landowners. And we do this through empowering Albertans through awareness on key issues such as renewable energy. And our office provides ongoing support for engagement and representation on those key areas of concern, information sharing through our publications and in-person sessions like this, or our social media, or even information on the Government of Alberta website. And our role is also to provide some advocacy with the agencies or the government departments on any legislation or regulations that can intersect with the agricultural industry. And we can also assist with any dispute resolution processes if there's conflicts between neighbor to neighbor or neighbor in industry or neighbor in the municipality. It's an entirely voluntary process, but what we try to do is we try to strive to provide some objective, unbiased advice and ideas that you might be able to take into consideration to help resolving that conflict. So what I tell people is, if you feel like this little guy running around with your hair on fire sometimes, just give us a call and have a chat with us and we can maybe help you out. So I'm going to power through a few of the next few slides, really just to provide you with a high-level overview in order to help you better understand the bigger picture or the drivers of renewable energy and why landowners are being tapped on the shoulder or approached by developers with a little more frequency in the last couple of years than they have been in the past. And really the first driver is policy. So you have to go all the way back to about 2015 when the Government of Alberta introduced the Climate Leadership Plan. And at that time it was a strategy to reduce carbon emissions, among other goals. Its aim was to phase out coal-fired generated electricity by 2030 and to generate 30% of electricity by renewable sources in 2030. And renewable energy resources means an energy resource that occurs naturally, that can be replenished or renewed within a human lifespan, including but not limited to moving water, so hydro, wind, heat from the earth, so geothermal, sunlight, which is solar, and sustainable biomass. So when everybody hears about renewable energy concerns, they automatically jump to wind and solar. So it's a much broader source of energy than just those two components. And since that 2015 time, we've seen a market increase in both the development of small and large scale commercial generation and micro generation and some community generation. Secondly, Alberta has some of the best combined resources for both wind and solar development potential. So as you can see, East Central and South Central Alberta have some of the highest or the greatest potential for those combined resources, and that's exactly where we're seeing a majority of the applications right now. So as a rule of thumb, solar projects generally require 5 to 7 acres of land for every 1 megawatt of energy produced. And that's all, of course, dependent on the output of the panels themselves, how much wattage there is. And again, rule of thumb for wind, it'll require about 1 acre of land for every 1 megawatt of energy produced. So solar is not usually defined as or considered as a dual use land footprint. Typically because it's not used for any other purposes other than just to put the solar panels on that footprint. There are some instances of sheep grazing within that footprint, but that's not really a common occurrence. There are some instances of it. It's starting, I think, to get to be a little bit more prevalent in some areas, but some developers are now starting to pilot what they call agrivoltaics, which is generating some agricultural industries within that same footprint, like garden market varieties of produce and some other shade types of vegetation that they're experimenting with underneath the solar panel arrays. So wind energy sites may entertain other agricultural uses because it's only just a small footprint that is taken up by the turbine, and other agricultural production and other agricultural operations can take place in and around that same pedestal area. So thirdly, the cost of renewable energy technology has decreased significantly. So over the past 10 years, we've seen wind costs falling by 70%, and the costs of solar installations by up to 90%. So perhaps more significantly is the levelized cost of wind and solar, which is a measure of the cost to construct and operate these power plants, may now show that renewable energy developments are close to or have reached parity with the marginal cost of installing and operating efficient natural gas facilities. This suggests that building, some of the renewables may now be cheaper for installing and operating than the existing fossil fuel power plants. So couple that with, the clean energy tax credit incentives, any carbon credit markets, power purchase agreements, a deregulated marketplace, a favorable supply and demand imbalance. These can all be incentives for further positive economics and continued growth and support of the renewable industry. And lastly, really is the growing appetite and the sense of urgency towards achieving a net zero decarbonized society. Currently, the greatest challenge for renewables right now is in the storage technology and capacity. Mainly in the forms of batteries, and that's just to allow for the direct transfer of power when the wind isn't blowing and the sun isn't shining into those times when we need it. So there are other mechanisms like pumped hydro or compressed air or electrolysis hydrogen production, kinetic storage systems, even small modular reactors. They're all viable in the energy mix, but many of them are really in their infancy right now. We're starting to hear a little bit more and more of the conversation of SMRs, the small modular reactors. So, that's a coming technology that I think you'll see more prevalent on site-specific areas like in the oil sands or remote areas or something like that. But it's on its way. I think some of the growing concerns that I'm hearing from landowners is really just related to the sheer size and scale of some of these developments that they're either being presented with or that they're hearing about in the media or that they're hearing about from the local coffee shop discussions. They're not all of this magnitude and they're not all this large. On the left is a 465 megawatt, it's Greengate Power's Travers solar facility. It's developed on approximately 3,680 acres of land. So that's just located in the Vulcan County, and there's in the range of about 1.3 million solar panels, and that footprint occupies about 23 quarter sections of land, so contiguous quarter sections of land, so fairly large. On the right, Greengate Powers recently announced their Luna solar project. It's another photovoltaic project comprised of a couple different phases. It's on adjacent lands, which has a potential for double the size of the Travers facility. So it's scheduled to come in with a nameplate capacity of about 930 megawatts, and it will be built on approximately 5,700 acres of land. So, and that's about 20 kilometers west of Brooks. And that site currently contemplates the use of about 2.2 million bifacial photovoltaic modules. Some of the other aspects that I'm hearing from landowners is related to visual aesthetics. They've been expressed that it's not just nearby that you're seeing these things. They're starting to elevate them a little more higher off the ground, and you can see them for a little bit more of a distance. So they'll sit anywhere from about 1.75 to 3 meters off of the ground. And it's like anything, the higher up you install it, the further away that you can typically see it. So like I said, most of the projects aren't of that mega scale. Most of them that we're seeing are going in around that 20 to 50, maybe starting to creep up to the 100 megawatt size. But most of the projects use solar panels that have an output of 500 to 575 watts each. And they can be arranged with a fixed tilt or a single axis tracking system that'll follow the sun throughout the day. And they can also be a monofacial or a bifacial module. So the bifacial modules generate electricity from both sides of the panel, either due to the reflection off the adjacent panel or off of the reflection of the snow. So the projects are not just the panels themselves. The other concerns that have been expressed to me have been what some of the developers didn't tell them was coming with the solar panels. And that's all of the electrical inverters or the pad mount transformers, the access roads, the office buildings, the electrical collector systems, the distribution and interconnection equipment, some of the communications and telecommunications towers, some of the storage systems, and all of the other ancillary equipment that comes with the whole development. So it's not just the panels themselves, there's a whole bunch of other stuff that can be installed, which again leads to some more of the visual aesthetics and some of the concerns regarding reclamation. With wind technology, the new technology and design and the size of the wind farm equipment is getting bigger and larger and actually dwarfing some of the original installations that we've seen in the southern part of the province. So some of the developments now that are being contemplated have hub heights of 185 meters in the air, rotor diameters of 170 meters, and blade lengths of up to 85 meters. I was out to an installation out by Manville this summer, and I was about maybe 200 feet away from the base, and I just about fell over backwards trying to look to the top, right? If you want to get a visual representation of just how large these things are, or how far of a distance you can see them from, just visually and aesthetically, take your time and go and see some. I think some of the closest ones around here are just that wind farm just out by Trochu. So they're large facilities. So if you want to get some aspects, just go and have a look at them for sure. Again, the rule of thumb, the nameplate capacity of some of these turbines can be anywhere from 2 to 7 megawatts of generation each. And again, requires about 1 acre for every 1 megawatt of power produced. And some of the other concerns that landowners have expressed to me is just some of the safety implications for aerial spraying or in proximity to aerodromes, the potential for property devaluation to adjacent residences, significant bird and bat mortalities as a result of wind generation, traffic disruptions during construction. These things are not small pieces of equipment, and if you've ever got stuck behind one in transit on a highway, you're going to be there for a while, as well as concerns related to setbacks and viewscapes and reclamation. So here's just a high level that outlines the roles of the different government organizations and agencies in renewables. So renewable energy is not regulated by the Alberta Energy Regulator. It kind of seems a little odd that renewable energy doesn't fall within their jurisdiction. It falls within the jurisdiction of the Alberta Utilities Commission. So the AUC is the regulator for renewable development. So that means that they're the ones that are making all the decisions on applications. They're a quasi-judicial and independent agency of the government of Alberta. They do not make the policy. Their role is really to protect the social, economic, and environmental interests of Alberta. And the AUC is governed by their own legislation that regulates Alberta's energy, resource, and utilities sectors. So they set out the rules and the requirements and the processes that the developers have to follow by the regulated utilities and the renewable energy operators that fall within their jurisdiction. Then you have the Alberta Electric System Operator, or the AESO. They manage the supply and the demand for electricity. So this involves planning, operating, building the provincial power grid. They're a not-for-profit organization. They have no financial investment in the industry, and just on behalf of Albertans, it's their role to work with industry and government to make sure that there's a reliable power system in place when we need it. Alberta Environment and Protected Areas, they're the primary policy maker for renewable energy considerations in the province with respect to environmental considerations. So they have the oversight for the environmental aspects related to the wildlife directives, and they also lead the regulatory initiatives on achieving the desired conservation, remediation, and reclamation outcomes at the end of life of the operation. And then there's our office, which I covered off in a little bit of the introductory slide. We have no legislative or regulatory authority or jurisdiction on the development of renewables. Again, our role is just like we're doing today, is to get out and talk to people, provide awareness, provide some timely information so that hopefully you can make an informed decision. One of the important aspects that differentiate renewable developments from the oil and gas industry, that many of you may already be familiar with, is that it's a voluntary participation in hosting a power plant, and consent must be gained from you as the landowner. If you say no, no means no, and there is no other recourse for that developer for a forced taking of land. There's no expropriation, there's no right of entry process, there's no forced taking. If you say no, they must move on. If you decline to participate in that development, there's just no recourse for that developer to gain access otherwise. And as such, the Surface Rights Act does not apply to renewable energy development. The leasing is a bilateral private commercial agreement between the two parties, you and the developer. And the typical heads of compensation that you might be familiar with under the Surface Rights Act or the oil and gas industry or electrical transmission companies, they're not applicable to renewable energy. So there's no entry fee, there's no land value compensation, there's no general damages, no inconvenience, no loss of use, and no adverse effects. Right? Those typical heads of compensations do not apply to renewable energy. You negotiate a lease price based on some other considerations and factors that I'll go through later. So again, because the Surface Rights Act doesn't apply, there's no requirement for renewal notices. There's no 5-year cycle for a rate of review of compensation. There's no remedy for a compensation hearing before the Land and Property Rights Tribunal. There's no remedy for damage claims, and there's no recovery of compensation mechanisms should that operator become insolvent and default on any of the compensation. So the way it sits with the oil and gas industry, if a company doesn't pay your annual compensation, you can make an application to the Land and Property Rights Tribunal for rental recoveries, and then there's a proceeding and a process, and you may get your annual compensation paid to you out of general revenue by the government of Alberta. That's not in place for renewables. That's all under the Surface Rights Act. However, keep in mind that if a developer does approach you and you say no, and they've highlighted your area or the local region as a good resource, if you say no, they may just go across the fence and talk to your neighbor, which in any instance you would have typically the same or very similar impacts, but likely none of the compensation. Since the Surface Rights Act does not apply, and there's no forced taking for the interest in land, the developer does not have to use a licensed land agent. Many of them do, but they are not required to. It's an entirely voluntary process if they want to use a licensed land agent or not. So there's no standardized agreement types for renewable energy leases. They're highly variable on a case-to-case basis. Some of you may be familiar with an oil and gas lease of 3 to 4 pages in length. The average renewable energy agreement can be up to 40 to 60 pages in length. So they're very comprehensive. They may have the same 20 to 30 year primary term of the agreement with an automatic renewal for an additional 20 to 30 years with a sunset clause in it that renewable clause applies to the renewable clause that applies to the renewable clause. So you could have that lease in perpetuity. There are few, if any, terms and conditions that allow you as the landowner to terminate a contract. However, there's normally several aspects in the agreement for the developer to do so. We highly recommend that before you sign any leasing agreement that you get a legal consult and try to find somebody with a competency in contract law and that's familiar and competent in renewable energy developments. Most of the developers that I've talked to have no problem in undertaking the costs associated with you undertaking a legal review, but if they put a cap on it of $250 or $500, that should be a red flag. You're not going to get a very competent, seasoned legal counsel for $250 or even $500 to review 60 or 70 pages of an agreement. So, like I say, just take that into consideration as a red flag if they start to put limitations on it. The agreement will typically indemnify the landowner from any accidents or damages during the life cycle of the development. We recommend that you get added as a third-party additional insured and get copies of the policies on an annual basis to make sure that they haven't dropped you from year to year. Some contracts will require the landowner to carry or increase their own farm or general insurance liabilities. So make sure you talk to your insurance brokers about what that might entail, because that could be very costly if you have to carry additional liabilities. Make sure you talk to your accountant, because there could be tax implications. Ensure to talk to your municipality, because there very well be rezoning or redistricting involved, and that could change or impact the tax assessments that are on that property. So be very clear on, even though that there's potentially a lucrative bag of money that they're dangling in front of you, you have to think about all of the other expenses that you're going to have to incur when you sign that agreement. So ensure you have clarity in the agreement of how contractual disputes will be remedied. Dispute resolution will typically either be in the form of an arbitration clause, but outside of an arbitration clause, you're in the courts to manage any of your conflicts. And that can be expensive, right? So just make sure you have that in your back pocket too, that there's some form of dispute resolution, because again, there's no property rights available to you through the Land and Property Rights Tribunal for any hearings of compensation or damages or anything like that. So you have arbitration or you have the courts. Very, very important is that you seek the clarity and certainty on the developer's commitment to look after the activities and the costs associated with the end-of-life obligations. So the decommissioning, remediation, and reclamation. Some will provide an irrevocable letter of credit. Some will provide bonds, trust funds, cash collateral, or other insurance provisions in favor of the landowner to look after the end-of-life obligations. and ensure that that security is protected from and included in any assignments from one company to another. We're seeing these companies change hands quite frequently, sometimes 4 times within the first couple of years as they're going through the development. And in some cases, that security provision may not follow the new company. So make sure that it's protected within an assignment, and ensure that in that clause that it's also excluded from any bankruptcy or insolvency proceedings. Because that's the first thing a creditor is going to come looking for, is to see if there's any cash bonds or irrevocable letters of credit or any other securities that they'll get their hands on. Okay? So you have to kind of ring fence that in your agreement to make sure that it's there for you as the landowner if the developer declines or is unable or unwilling to look after the end-of-life obligations. The security provisions in there should also cover off the provisions for a default in property taxes. Renewable energies is not excluded from the Municipal Government Act like the oil and gas facilities are. So if that company fails to pay their property taxes, you as the leaseholder and the landowner could be liable for those taxes. We haven't seen it yet, but there are provisions that the municipality could come to you to satisfy that annual tax obligation, and that can be in the millions of dollars a year. So again, a lot of money up front when you sign, but what's the risk on the back end too? The AUC, their Rule 7, that's the Bible for all of the applications. They require a proponent to provide the AUC with an overview of how they intend to manage the end-of-life obligations, but it doesn't set out any specific parameters of what that security should be, what form it's in, or any minimum security requirements. Basically what we've seen is developers have gone into the AUC and says, trust us, we've got an agreement with the landowner that says we'll look after it, so we're all good. So, take that into consideration when you're having those discussions. There's also currently no provincial funded backstop or framework like there is with the oil and gas industry and the Orphan Well Association, that if there's no responsible party at the end of the day, there's no funded liability organization to go in and do those cleanups. You as the landowner are responsible for doing that. If the company, and that's why there's security bonding and those security end-of-life obligations, that if the company walks away, you at least have some funding and some ability to manage that end-of-life obligation. Ensure everything is captured in writing. It's just like what happens in Vegas stays in Vegas if it's not in writing. Some of these contracts are going to fall to your grandchildren's grandchildren. And you're not going to be able to prove what your great-granddad said and did, and the verbal commitments that they've made and the handshakes that were provided. Whatever you have as a commitment or discussed at the table needs to be put in writing, and it needs to be formed as part of that agreement. Some of the other considerations you want to think about is how will the access be handled throughout the stages of the development. Will you be permitted to use the access roads? How will they be maintained? Some contracts that I've seen are really all-inclusive. They don't provide for any additional payments for crop loss or damages. Once you sign that agreement, you're giving that company carte blanche and exclusivity over all of those lands to go where they want, when they want, how they want, in any manner they want, and not have to pay damages. Your base rent is supposedly meant to cover all of that, so they could drive right through your crop to get from point A to point B, and there's nothing you can do about it. You're already being compensated for it. Talk to them about the fencing needs, the weed and vegetation control, biosecurity controls, like for clubroot. Even gophers are starting to crop up as being a problem. Not too many people let you, shoot gophers in and amongst the solar panels and within those footprints. And wildlife are smart at times. They know that there's no predators in and around those areas, so they hang out in the solar farms and then they come out and eat your crop in the afternoon. So get it in writing, something that outlines any of the clear and detailed understandings, including the management of any aggregate and topsoil. So some of the lease agreements will take priority over that. So if, when they're doing their construction, if they happen to find some aggregate operations or some deposits, you've leased that land to them. They'll take it, they'll sell it. They have even taken topsoil, moved it and sold it, right? So these are some of the things you just have to have that conversation with them about. I'm not saying anything to deter you from hosting a development. It's just, here's some considerations that you want to make sure that you cover off so that you're not surprised at the end of the day. Setback restrictions are imposed by the developer and by the municipality. They may be a result of land use bylaws, noise propagation, glint and glare assessments, and shadow flickers. So it may restrict your ability to subdivide, construct any other residences, erect barns, sheds, install grain bins. Basically just about everything that you do in proximity to these developments, you can't do without their express written permission to do so. Be certainty and gain clarity on any of the opt-out and termination clauses. Like I said, there's typically several avenues for the developer to do this. Just be aware of how and when and what kind of triggers are in place for those agreements to expire or be terminated, because it'll affect your long-term planning as well. They do a fantastic job of showing you the potential, but make sure that they also, the potential for compensation, but make sure that they also walk you through all of these other risks and potential impacts. Be aware as well that there's typically a confidentiality clause or a non-disclosure clause in the agreement that prevents you from discussing any matters of that agreement with immediate family members, friends, and neighbors outside of your legal representation. So if you want to talk to your extended family about it, your brother-in-law, your sister-in-law, your boys, or your daughter that want to take over the farm, you have to get their permission to talk to them about it. Otherwise, you could be facing legal action for a breach of confidentiality. They do that by design because they don't want you talking to your neighbor to see what you've negotiated. They don't want you to be talking to another developer who might be in competition with them. There's those types of things. Remember, everything's negotiable, and they need your consent to proceed. So my advice would be to strike those types of clauses out, because to me, and this is just my personal opinion, it's not a Government of Alberta opinion, to me it's ludicrous that you can't talk to your sons and daughters and brother-in-laws and things like that, because these are long-term agreements. You need to have those discussions for your own farm planning as well. To make these decisions in isolation are having long-term impacts on future generations. Right? That's just my view. There's typically an option to lease, especially with wind. We do see it with some solars. This is just a period of time that the company spends in doing all of their studies, their data gathering, and any work preparatory to an application or a final investment decision. And this lease of an option also commits the landowner's lands to the company for a period of time at a prescribed rate of compensation. Much, much lower than your ongoing rent should they decide to have a development. The options provide exclusivity to the developer where no other contractual land use agreements can be entertained, such as pipelines, oil and gas facilities, rents, occupants, or anything like that without their express written permission. It'll restrict you from, like I say, renting your land, selling your land, mortgaging your land, right? That lease is under an option, and basically you've provided them exclusivity to it. You can still have those conversations about it, but they just have to agree to whatever you're going to do within that period of time. And that could be anywhere from 3 to 10 years while they're doing all of their studies. They don't have to lease your land at the end of that option period. They could just walk away or go adjacent to you. They're based on, the options are based on either actual intent to develop or just speculation where a land broker is going out and they're putting together a land package that they're going to broker to another company because they're doing all the legwork, and they'll say, we've locked up 40 contiguous quarter sections of land, we'll sell you this. right? So there's speculators out there. I've looked up some of these guys that are out doing some of these land negotiations, and yes, I mean, many people are working from home because of COVID and stuff, but this happened to be a residential basement suite in Calgary. So, you know, I'm not saying you shouldn't work from home out of Calgary, but you know, there are some things that kind of raise some red flags for me. It's important to recognize that the compensation scenario that they provide you is the best case compensation scenario, and it may even be overstated. Have the developer walk you through the scenarios of timing, the associated compensation, so you have a clear and realistic view of the actual costs and the risks. There's no standard for a compensation structure. They can either be fixed structures, variable structures, or a combination of fixed and variable. So the fixed, that's just a base rent that you get paid regardless, you know, every year, regardless of what stage the development's at. Or variable could be based on a percentage of the production or a percentage of the economic generation of the project. So we recommend that you negotiate some fixed price at the very least, some fixed rate, and then look at negotiating potential variable rates. Because if you base it all on a variable rate for specifically that turbine that's on your place, and it doesn't run all the time, well, you're not generating any income, and it's all based on management decisions, power purchase agreements, everything that's out of your control. So that's why we recommend just negotiating some form of fixed agreement. It's important that you understand the activity timelines with the compensation. You could get paid a rate during the option period. You could get paid a different rate during the construction period, a different rate for the operation period, a different rate for the reclamation period. So, and all of those rates can fluctuate based on the timing and the milestones and where that development and project's at. So just because somebody's going to offer you $900 to $1,500 an acre for that lease, that might be just for the operational period. It might only be $40 an acre for the option period. Right? So make sure that you have awareness of all of those components. I get a lot of calls about from landowners say, why didn't I know about this? Like, this thing's going in, a couple miles down the road. I had no idea what's going on. Why is this thing going in? Well, the developer's required to conduct a thorough participant involvement program, and that includes notification and personal consultation. The AUC Rule 7 again, it states that all persons whose rights may be directly and adversely affected by a proposed developer or proposed development must be informed of the application and have an opportunity to voice their concerns and have an opportunity to be heard. So the engagement activities must be conducted with all occupants, residents, and landowners within varying distances of the project based on the project's type, size, capacity, and whether or not it's supposed to be situated in an urban setting or in a rural setting. So the example that I've highlighted here is just for a solar development over 10 megawatts, and whether it's urban or rural, the notification radius is 800 meters, and the personal consultation radius is 400 meters. So if you live 1,000 meters away, or have land holdings, within a kilometer, you may not have been notified, because these are the minimum notification requirements that the developer has to adhere to. Right? So that's why you didn't hear about it. The next wave of technology hitting the landscape is the battery energy storage systems, or your what we call BESS. They're becoming more common as part of a standalone application for power generation facilities, or included in the power generation facility application itself. The idea here again is to generate power, store it during periods of low demand and low prices, and then discharge it when there's high demand and high prices. So the majority of concerns here are related to the safety aspect of lithium-ion batteries. Not all lithium-ion batteries, some lithium-ion batteries. And it's a condition called thermal runaway. And when a battery cell fails or becomes compromised, it can encompass adjacent banks of batteries and even engulf the whole battery storage facility, or even the solar facility itself. So basically, without a complex and elaborate gas detection and fire suppression system in place, all emergency responders can do is stand back and let these things burn. They will control the area around the compromised battery facility or cool off adjacent batteries, but they really can't put these things out, right? They really have to just let them burn and do risk mitigation for everything surrounding it. So it's not just the risk of fires moving adjacent, there's also the toxicity of the plume from the burning facility itself. So if any of you here have ever burnt twine in a big pile from the bales and stuff like that, that noxious smell, multiply that by a few degrees, and that's what you're dealing with. It's basically an electrical plastic fire, right? And that toxic fume can be hazardous. The photo on the right here is a 100 megawatt battery storage facility in the US. I'm not sure who the developer was, but on the right is TransAlta's 10 megawatt wind charger facility in southern Alberta. It was the first utility scale lithium ion battery storage facility in the province. We're starting to see more and more applications with these come through all the time. Renewable energy projects, they're designed to last anywhere from 20 to 30 years on their primary installation. And it's entirely possible that the equipment could be replaced at the end of that 20 or 30 years and be repowered. Currently, the developers are advising that the salvage value will offset much of the cost of the decommissioning. Again, to me, that's a little bit speculative to see what the cost of decommissioning and what the cost of the materials are going to be on salvage 30, 60, 90 years from now. So, you have to take that into consideration. Some of the materials currently can be recycled and reconditioned and reused elsewhere, but currently we're seeing the majority of it ending up in landfills. It's one of those things that if you build it, they will come, and supply and demand. Right now, there's not a lot of solar panels and wind turbine blades and components that are being recycled or are even at the end of their life. So there's not a robust recycling program currently in place because nobody's going to build something like that until there's a supply and demand. Once a lot of these things start to reach the end of life, the Recycling Association says, yeah, you bet, we'll take care of it then. So again, future planning, adaptive management, just taken into consideration. All of the below ground structures have to be removed to a depth of 1 meter, unless it's a concrete pedestal or some pad mounts or something like that. Then the developer must remove it to a depth of 1.2 meters. So if you have deep tillage or you have a need for that to be removed to a greater depth, you need to negotiate that in the contract up front. Because 30 years from now, if you say, no, I want it pulled out to a depth of 3 meters, or I want it all pulled out, they're going to say no. Contractually, your great-grandfather agreed we only had to pull it out to 1 meter. So anything greater than that will remain in place. And then once the decommissioning activities are completed, the land reclamation portion falls. So when they decommission it, unless it's repowered, they'll remove all of the above ground stuff. They'll remove all of the buildings and the pedestals and the racking for the solar panels. So the only thing that you'll see are the collector lines and everything that's below ground. Reclamation, that'll include restoring the landscape and establishing the vegetation, no differently than the oil and gas industry does. So in 2017, the Environmental Protection and Enhancement Act was revised to include the addition of renewables. So wind and solar power generation is now considered specified land in the Conservation and Reclamation Regulation, no differently than the oil and gas installations. So they must meet the same equivalent land capability designation at the end of life. Right? So it's important to remember that equivalent land capability definition, because the CNR regulation, Conservation and Reclamation Regulation, defines equivalent land capability as the ability of the land to support various land uses after conservation and reclamation, and that it's similar to the ability that existed prior to the specified land activity being conducted on the land, but that the individual land uses will not necessarily be identical. Right? So they will try to their very best to meet equivalent land capability. So if it's cultivated land surrounding the development, they have to meet the same cultivated land capability. If it's a peat land, if it's grassland or forested land, they have to meet that land use capability. And it should be able to provide similar, but not identical, but the same yields and land use as existed before the footprint was installed. The operators have to conduct a reclamation certificate site assessment. So no differently here again than oil and gas operators. And they must meet the same 2010 reclamation criteria for well sites and associated facilities that the oil and gas industry does. And those lands, because they're specified lands, they must get a reclamation certificate. And this time it's issued by Environment Protected Areas and not the Alberta Energy Regulator like there is for oil and gas. So that's why it's important to stay engaged, throughout this whole development to ensure that the operator's meeting their commitments that are specific to the compensation and to the financial aspects as well as the reclamation obligations. A little bit of a miscommunication and misconception that the renewable energy developments don't have much of a legislative or regulatory background. That's not true. This is just some of the acts and the regulatory instruments that are in place that provide jurisdiction and authority and direction to the industry. The key ministries in this through the government are affordability and utilities, environment protected areas that we talked about, arts, culture and the status of women, and Indigenous relations. So if you have concerns about post-approval of the development, either during the construction or through the operation phase or through the reclamation phase, you can contact the Alberta Utilities Commission, and they have a very simple complaint form and a very simple process for you to provide them with your issues and concerns. And then any of the proponents of the renewable energy projects, they have an obligation to comply with all of the orders and the requirements that were attached to their approval or the decision that the AUC had issued that related to that project. And if there's any evidence of non-compliance with any conditions that were attached to that decision from the Commission's approval, it can then be addressed through the AUC's enforcement program. In addition, there's site-specific regulations, protocols, directives, and guidelines that address other impacts related to environment, noise, solar glare, shadow flicker, wildlife, safety for aircraft. Some of the more, prominent rules that you need to be aware of is Rule 7. That's the application for power plants. Rule 12 is their noise control. Rule 33 is their post-approval monitoring requirements, where they have to go and do wildlife studies to see just how many birds and bats and other things that they have for fatalities. And Rule 24 is microgeneration. So if you're thinking about putting renewable, on your own barns and sheds and roofs and generating your own electricity to help you get off the grid, that's the regulation within the AUC's jurisdiction as well. You may have heard that on August 3rd, the Government of Alberta announced a pause on approval of renewable energy projects, and just to provide time to the Alberta Utilities Commission to hold a public inquiry about the competing public interest factors raised by the renewable energy generation application. So more specifically, the government enacted what was called the Generation Approvals Pause Regulation. And that prevents the AUC from actually approving any new renewable power plant applications over 1 megawatt for wind and solar. The pause granting new approvals does not apply to power plants that produce less than 1 megawatt or are isolated generation unit, like behind the fence renewable power plants. Any sites where the power plant is producing 5 megawatts, but it's being totally used by the proponent behind that fence. So they've also ordered the AUC to host the inquiry and to gather evidence from the public about the development of power plants on specific classes of agricultural and environmental land. The impacts of power plants on pristine landscapes and viewscapes, the mandatory posting of reclamation security by power plant proponents, and the development of power plants on provincial crown lands, and the impact and the growth of renewable power generation supply mix and electrical system reliability. If you go to the AUC's website, they have all of the bulletins issued for all of the consultation and your avenues to participate, whether it's through written submission, whether it's through open houses. I think the closest one here is in Red Deer on November the 2nd at the Radisson Hotel, and there's one in Medicine Hat and Pincher Creek. But written submissions are due by November 22nd, and they have also prepared a comment matrix that's accessible on their website for you to provide feedback into these inquiry topics. They also recently released some interim information requirements as part of new applications. So you can submit an application, they won't approve it until after the pause is concluded, but any applications that are received after September the 6th hasn't implemented any really new requirements, but what they're asking is the proponents to do is to be more fulsome and provide greater detail on these aspects as part of interim requirements for any new applications. So they need to describe the agricultural capability of the soils intersecting the project footprint, because that was the biggest concern that our office was hearing as well, is the taking of prime agricultural land for an industrial footprint. And there was a lot of pushback of the prime agricultural lands being taken out of production. So they need to, now proponents need to describe to better detail what those lands are and what classifications they are that they're proposing to use. Municipalities also raised a lot of grave concerns that they weren't being engaged in a fulsome manner either, and that there was a lot of conflict with area structure plans and the land use planning and the bylaws that were in place. So now the proponent has to confirm whether the proposed power plant complies with all of those applicable municipal planning documents, including the development plans, area structure plans, land use bylaws, and municipal bylaws. So a little bit more onus to have greater consultation with the municipality. Viewscapes, they're now required to list and describe any of the pristine viewscapes which the project will be imposed upon, and describe any mitigation measures available to minimize those viewscape concerns. As well, further information to describe the reclamation security requirements, provide more information of how it's going to be calculated, how often it's going to be calculated, how is it going to be released, when is it going to be released, and what form that that security is in. So a little bit more detail is going to be required going forward. These are just interim requirements. If there is anything that comes out of the inquiry, it may or may not include those interim requirements, or it may be different requirements. Okay? So a lot of people just phone me and say, what can I do? Like, this stuff is going in, I can't stop it, or I can't seem to find out how I can participate. It's a new industry, what can I do? So my advice is really three things. Participate, participate, participate. Right? No one is going to assume that you have an issue and a concern, or no one's going to assume what your feedback or your interests or your thoughts are unless you provide them to the inquiry or provide them to the AUC. So familiarize yourself with the AUC's rules and the decisions and how to participate in those proposed developments and participate in the inquiry. And you do that by registering and signing up for a profile. You have to put in, create a password and a login and stuff to the AUC's e-filing portal. That's that green e-filing system. It's accessible through the AUC's website, but it's called the e-filing system, and it's very clear directions and explicit instructions on how to register for that. And the e-filing system, that's the online tool that's used by the AUC and the proponents to assist and manage any information sharing or anything about applications. Absolutely everything that the developer puts forth to the AUC for them to look at to decide an application is housed in that e-filing system, and absolutely every document, all of the correspondence back and forth for information requests or supplementary information requests or clarifications is all available to the public. So there's way more transparency in this system than any other application format that I'm aware of. So you can go on and you can log on, you can sign up for notifications for any applications either near you or a specific type of an application, whether it's a thermal power plant, a solar development, a wind development, and you can get those notifications at the same time as the applicant sends their information into the AUC. So I highly advise you to, have a look at that e-filing system. It's used by all the proponents to file all of the application documents. Tromp around the ASO's website. They have a whole pile of information on their role and how they interact with the power grid. They got a lot of videos and resource materials to try to help understand, the pool pricing, to understand how the proponents get permission to attach to the grid, and all of the stuff that goes within the planning and the development of the power of the grid. Stomp around some of the renewable energy sites, the Government of Alberta site. And I'd also like to note before closing that the Farmers Advocates Office has developed a publication called Negotiating Energy or Renewable Energy Leasing, and it's landowners' considerations and common questions. So it's available for viewing on the web and download. So just about everything that I've mentioned tonight is available in that document online. So if you were worried about taking copious amounts of notes and try to remember everything tonight, jump onto the Farmers Advocates Office website and look for that publication. It's under the Surface Rights and Renewable Energy tabs. We're pretty easy to find. Just a quick internet search for the Farmers Advocates Office or 310 Farm. If you call the Ag Info Center and tell them you have questions about energy development, oil and gas, renewables, they'll pop you over to my office, or you can call them to contact me direct. Like I say, pretty easy to find. And I know that's a lot of information. Let's get and drink from a fire hose. But with that, I'll take any easy question.
There's got to be at least one question.
Either that or I put a lot of people to sleep. Like I say, there is a pile of information. Like I say, I want to reiterate, I'm not here to deter you from entering into or hosting a renewable energy development. I just think it's important that we flag a few things, because many times what I'm finding, and it's not just with the renewables. If it's a new industry or you're not intimately familiar with it, I mean, it can apply to oil and gas or electrical transmission or anything else. Sometimes you just don't know what you don't know, and you don't know what to ask. And then people kind of feel intimidated or overwhelmed with the process, and they really have a hard time with these kinds of decisions because they know it also affects their neighbors. And you're also making that decision for future generations. I get just as many calls from landowners saying, Darcy, I can't turn this down, right? I mean, it's more money than I can make, with canola snow at 25 bucks a bushel. I have no input costs. I can sit there with my feet up on the couch. I can actually diversify my operations. I can lease out, 4 quarters of land, and I can pay off the mortgage, or I can help set the boys up with their plan, or I can, replace some of my equipment. But I just know that if I agree to this, my neighbor is never going to talk to me again. So, it's kind of a dilemma, right? I think it's important that you do share information amongst each other at a community level too. Because yes, I mean, you're making a decision that could impact your neighbor. But I've also had guys phone me up and say, Tell these guys to mind their own business. It's my land. I'll do with it how I wish, in whatever manner I want to, and they can mind their own business, right? So it's a very difficult situation. Now, having said that, that it's a voluntary process to host renewable energy developments on your lands. If that development involves transmission lines to get that power from point A to point B to tie it into the grid, establishing transmission lines is a forced entry. So if you say no and they go a couple miles down the road and sign up your neighbor, you may have a transmission line come across your place and then you have no say. Now you're into participating into a land and property rights tribunal process. So those are the other questions, is don't just tell me about what you're planning, for putting the power generation site. How are you planning to tie it in? Is there going to be further construction of distribution lines, for transmission lines? Like, give me the 50,000 foot view of what I need to take into consideration to help me with my decisions, right? So when everybody says, yeah, it's a voluntary process, yeah, but, right? So you have to have a little bit more knowledge and ask the hard questions, right? And, I've done presentations to the industry side of things too, and I've let them know that landowner questions does not mean that they're opposed. They're just seeking to understand. So don't have your land brokers or your land agents discount the landowner that's asking the million questions, because they're only doing their own due diligence. So if you're finding that there's landowners asking a pile of questions, don't dismiss them and jump across the road because you think that the uninformed or the absentee landowner is going to be a better fit, right? Yeah.
So if you're right next door to one, and all they have to do is come and talk to you, they don't have to agree with anything?
Correct.
If they talk to you, they're good.
Correct, yeah. So there's no confirmation of non-objection for those developments like there is with the oil and gas industry or pipelines or something like that. They just have to notify you, and or personal consultation just means they sit down at the kitchen table and they have a discussion with you. Notification just means they send you a letter.
Yeah, but if they're that close, you gotta come and sit with you, but there's nothing you can do about it.
No, there's no confirmation of non-objection required. However, if one person opposes the development, the AUC must hold a proceeding or a hearing. So that's your avenue of revenue or remedy to oppose. If you have issues and concerns that are unresolved, then you can file a statement to participate with the AUC through that e-filing portal. You have to register, but you cannot register until the application is received, right?
And it's probably not going to be turned down because they're going to have a lot of money into it by that time.
Yeah, you're right. I mean, there are very large capital expenditures. By the time they've made that final investment decision, they have a pretty good idea of who's going to oppose it, and they'll set aside monies to kind of fund a hearing proceeding. Yeah. Now, having said that, don't be deterred in participating, because there's also funding of your costs that are reasonable and that were beneficial and helpful in the proceeding. It doesn't mean it's a blank check, but you do have the ability to get your costs recovered if you wanted to represent yourself, for any of your direct out-of-pocket expenses, any legal representation, any professional advice of an agrologist, or whatever that professional is. Just know that the AUC has discretion in what those costs award would be. Doesn't mean that you're going to get every cent paid for, so just be aware.
Basically just delaying
I wouldn't say that. There have been recently 2 solar developments that have been denied, and those are recent.
What for?
They were denied on environmental concerns, mainly due to the wildlife concerns, either too close to a habitat where it was deemed a high risk for avian fatalities. Yeah.
Has the government come out with any new rules that are going to help us or hinder us?
So that's part of what the inquiry is being held for, to see and gain feedback from the general public, from industry, from the service and supply industry or side of things, all of the vendors. They want to have information to decide whether or not the current regulatory and legislative framework is meeting the needs of the public interests of the province. And if they feel that it isn't, they may bring in any new legislation or regulation. Regulation is much easier to implement than is legislation, because legislation, once you start getting into acts and regulations, then it's a whole different ball game with getting that stuff put in place. Yeah. So I would say stay tuned, but again, remember the three things: participate, participate, participate. Nobody's going to assume that you have any issues and concerns, or that you're opposed to it, or that you're in favor of certain aspects or opposed to certain aspects. They can't guess, right? And they're not going to, try to put anything new in place unless they have, bona fide evidence and feedback from all of the participants that it's required. Yeah.
Is there any compensation for the mineral rights or gas rights on solar?
No, there's not. So there was recently a court case regarding that, and it was not favorable to the mineral owner, the outcome. Yeah.
So the same thing applies there as it would be for land values, if they depreciate because of these solar farms. Now, they claim now that there is no decrease, like, what's it, 5 years, 10 years?
Right. So it has been confirmed in a few recent proceedings at the AUC that they have affirmed anywhere from up to 5% property devaluation to adjacent residences. Right? So overall property devaluation would be difficult to prove, because you would have to show that no one would buy it simply for the fact that that development was there. Right? It's a difficult concept to prove property devaluation because of a specific instance.
So residences,
Residences, they have affirmed that there is an impact to residences, not just land. So just living adjacent to it has shown to, through the property evaluators, professional property appraisers, can show or have empirical evidence that I believe up to 5% of the residential value can be depreciated.
One for the reclamation, how did they come up with a number?
Basically, an estimate. They will have their service and supply and their vendors give them a quote on what it would take to remove the pilings, whether they're pounded pilings, whether they're screw pilings. Then they'll look at the salvage value or the recyclability of the aluminum and the components and stuff. And then, they'll have a detailed site assessment for any remediation or reclamation. So basically, it's all just an estimate right now, based on information that they know today.
Today's money.
Today's money.
Not 4 years down the road.
Correct. So so one of the recommendations that I would make is when you're putting those lease agreements in place, have some form of consumer price indexing applied, right? And or make sure that there's some kind of an inflationary mechanism for tomorrow's prices. And more importantly, to have that assessment reviewed on a periodic basis, right? Every 5 years, especially. Don't wait, or I would not agree to a company saying, 10 years out from the end of life, or 5 years out from the end of life of this development, we're going to start to fund a reclamation security account, right? Well, that's fine, as long as you're in business from day one to that time. Because at any point in that time, if you become insolvent or for some whatever reason, end up in a receivership or bankruptcy, now there's no security, right? So I would say make sure that you have security provisions from day one to the end of life. Yeah.
Written in stone.
Written in stone, well, written on something, for sure, for sure. Yeah, and I can't emphasize it enough. These contracts and these lease agreements are very, very comprehensive, and they are written by the developer's lawyers. And they are so full of what ifs and whereas and such tos and in case ofs that I have difficulty, and I've read many agreements. I have difficulty at times actually saying, okay, so what does that mean, right? So, and when will it be applicable and stuff? So it's very important to, it's crucial to get a legal review, for sure.
So you're saying you've read a few, it's supposed to be confidential, but
Right.
anyways, what are they paying? Like, what's the minimum maximum right now, you know?
I'll give you a legal answer. Some money. So I've seen contracts because people have shared them before they've signed them, right? So they're really not enforceable. There wasn't anything in there. And in every instance, they have gotten permission from the developer to share them with my office, right? So anybody that phones me up and says, hey, can you have a look at this contract? That's the first thing I do is say, does it have a confidentiality agreement, non-disclosure agreement? They say yes. I say, run back, get permission, because I don't want to put you in any kind of trouble. So the rates vary, and there's no established database. And it varies from company to company, it varies from area to area, it varies from project size to project size. Anecdotally, I've heard anywhere from $900 to $1,500 an acre, or up. That's for solar development, and up to around that $3,000 or $30,000 per turbine. Now, don't put that in writing. That's just what the senators have told me at the coffee shop. So sometimes they can tend to embellish things too. So it's all over the place. But remember, everything's negotiable too. Like I say, I'm not here to scare you. I'm just here to have you just take a few things into consideration so that you can make a better informed decision and maybe learn a bit more. Ask the questions that you just never knew what to ask. Talk to some folks that do have developments on their land. It's very simple to find a turbine or a solar site, and for $5 you can pull title, and you can see who owns the land. And they may tell you to mind your own business, but I think it's important to have some conversations with people that have experience. Just about everything that I've learned to put into some of these presentations have come from landowners that have had these experiences. To say, I didn't know this. Did you know that? Right? So it does help to form that kind of community intelligence. Don't be afraid to reach out to your neighbors or friends or stuff and just say, how did it go? What do you like? What don't you like? Was it a good decision? Do you lose sleep over it?
Are there lawyers specializing in this, or do you guys have a list?
So we used to refer everyone to the Law Society of Alberta. They have recently, as in the last 30 days, I think, or 60 days, discontinued the lawyer referral service. You used to be able to phone there and say, I'm looking for somebody who's specializing in contract law, renewable energy and stuff. Unfortunately, we as the government, through the Farmers Advocates Office, we can't refer you to any specific firm or lawyer. But if you go to your guy in town, or the gentleman or lady that you currently use, and ask them what their competencies are in contract law and renewable energy. And if they're a little hesitant, then they should be able to help you with a referral to another firm or another lawyer that they have. Yeah, good question. I'm glad you brought that up. Because the lawyer referral service was our go-to. Call them, the Law Society of Alberta. They have a number of lawyers, or used to have a number of lawyers listed that they could contact for different specialties. I'm still waiting for the easy questions.
So,
Yeah.
what would you do if you'd have some land and it come to you?
Yeah.
Would you let them go in?
If the terms were suitable to me, yes.
Okay, you just mentioned here 1,500. You let them go in for 1,500?
Again, it would have to depend on the whole development, not just the money, right? So if the terms and conditions are favorable, yeah, I mean, it's a decision. But you have to look at more than just the money, right? And you have to look at your values, look at, you know, what your long-term planning is. Is it going to, benefit your current operations? Is it going to, specifically impact or hinder your operations? It's a very individual decision, and by no means should you base your decision on anything that I've said.
What's the price based on?
Really, it's what the market is going to bear. If they feel that they're going to be able to get an agreement at that price, then they'll negotiate that price. If they have to feel, or if they feel that they need to increase it to get an agreement in place, then they may. Everything's negotiable. Again, I just would caution you on making your sole decision based on the compensation.
You ever had anybody ask you, let's say you have a quarter of solar panels and you got 3 or 4 pipelines running in there and one needs to be replaced, how do they do that?
Yeah, that'll be the contractual agreement that they have with all of the third parties who also have an interest on that land. So if they do the development, they cannot develop within that pipeline right of way without the express written permission of the pipeline owner. Right? So they'll have to have those other discussions with that third party. Yeah. Again, there's got to be an easy one.
Do they hold a mortgage on your land?
No, they don't hold a mortgage, but you would very much need to, if you do have a mortgage, you very much need to talk to your bank or to whoever holds the mortgage, because the leasing agreement may subordinate any of the value of the materials on there to their creditors and not your mortgage lender, right?
Because I had a guy say that
Yeah.
if they went to the bank and the bank wouldn't give them a
Yeah.
mortgage because that
Yeah, because they're not going to lend you money if all of the value and the assets of that land is already spoken for,
for there.
right? Is already, subrogated to the creditors who are financing the developer, right? So yeah, like you say, talk to your accountant, talk to your banks, talk to your municipality, make sure you have a good overview and an understanding of those kinds of implications, right? Even if you decide to sell your land, you may need to get their permission to do so. And the new owner may have to execute another agreement or sign on to and accept all of the terms and the conditions of the agreement you signed.
They must put caveat on your title then.
Yes. Yeah. Yeah, and a caveat, you have to remember, a caveat's just a warning. It just tells others that, hey, I have an interest in this land, and that interest happens to be a lease agreement for the solar development, right? Yeah. Okay, well, if there's no other questions, hopefully it was some beneficial information, or at least something to think about on the way home, or to start to talk to people. Or is anybody here currently reviewing a proposal to put a development on your place? Okay. Yeah. So these are some of the questions. Did you have all of this information before you walked in tonight? Of kind of.
I spoke to you on the phone about a month ago.
Was it a good conversation?
Yeah.
Yeah. Okay. Good. As long as I didn't give you some erroneous information, it's all good. Yeah. Yeah. So just take your time. Don't feel rushed. and ask a lot of questions, right? Ask a lot of questions.
If you don't want it, can you just say no?
Absolutely. Yep, if I come knocking on your door and said, sir, would you be interested in hosting a renewable energy development? And you say, no, thank you, then I have to go somewhere else. Oh, sorry?
Any numbers, figures for how long these panels, wind turbines, their lifespan?
Yeah, so the lifespan, right now, industry is telling us is between 20 and 30 years, closer to that 25 to 30 years for the primary installation. And that doesn't mean that the solar panels are no good. That just means that they may have dropped down there in efficiency to about 80% of what their nameplate capacity is. So they've also advised that there's going to be a market when we repower. If we decide to repower that site, we'll take all of these used panels off and we'll sell them to a secondary market of homeowners who want to put them on their place at a reduced price, or RV owners who want to, put them all over the top of their RV, or anybody who wants to look at doing some micro generation. Right? They see that as a very lucrative market in 20 to 30 years. So again, it's the same for wind turbines. They're a little tougher to repower because the engineering of the base and the pedestal to hold the nacelle and the whole turbine, you could replace it same with same, but the way that the technology is, in 30 years, it's speculative to think that they would be able to find the same 30-year-old piece of equipment in new condition to put on top of there. So yeah, there's question about the repowering of wind turbines, whereas they might just be able to replace some of the components of the generation within the nacelle and not have to change the height or the blade length and such like that.
And that's what you're getting paid on, is if there's some power in the generator.
If it's a variable contract that's based on the power generation or the economic production of the solar development or the wind turbine, yes. If it's a variable rate, if it's not generating electricity, you're not making any revenue. So that's why we say it's better to have some fixed component that you're getting paid on an annual basis regardless of the status, regardless as to whether it's generating power or not, so that you have that stability of income. So it's speculative to just put all your eggs in one basket and say, yeah, I'm going to make a pile of money because this thing's going to be turning all the time. Not so.
So the reclamation, like those wind towers, that cement goes down how far? Like, I don't know, like thousands of feet?
No, 6 or 7 meters.
Oh, is that all?
Yeah, so they're fairly robust. They're built like a cone, right? And I can't remember, there's something like 850 cubic meters of cement in there. But they feel that they won't impair future agricultural operations if they remove the top 1.2 meters of cement and then fill it in with dirt.
Do they have to maintain depth of cover?
Pardon me?
Rocks always come to the surface.
Yeah, so if you have deep tillage or putting any water tiling or any of your own excuse me, pipelines or anything like that, then that's a consideration that you want to have in place up front before you sign that agreement, is that they remove it to a greater depth to allow you to, not to impede any of your agricultural operations.
They try and put it on the rock.
Sorry?
Are they obligated to maintain depth of cover?
Yes. Yeah, so that's still part of their reclamation certification requirements, is it has to maintain equivalent land capability, and if there's any slumping or problems, like even if it gets covered with weeds or something like that, they're still on the hook for it. Yeah, just like the oil and gas considerations, that 2010 reclamation criteria and getting a reclamation certification. Yeah. Perfect. Thank you for having me. Like I say, 310 Farm. That's all you have to remember. He got a hold of me, so if you forget what number to call, go after him. He's got my number.
I forgot already.
Yeah. Thank you very much, everyone. Appreciate the invitation.
couple things. So on behalf of the County of Stettler, thank you very much for coming out.
You bet.
Darcy came out, it would have been summer, I think, presented to council, actually to the board, Ag Service Board. Very similar talk. So that was recorded. It's on YouTube on our Stettler site, as well as tonight. We've also recorded, so if there's something you missed, you want to go over back and replay it, give us till end of day on Monday to upload it, but go to YouTube on Stettler County and you can listen to the whole thing again. A couple of things at the back. My friend in the plat is holding an evaluation. Please take the time to fill it out. Front and back, it's really quick. Gives me an idea if I'm giving you guys what you want. You want to see something different. Yeah, that'd be appreciative. There are some pens back there as well. There's also a copy of the land use bylaw at the back on that table. It is going to be under review shortly between 2024 and 26. We'll open it up and start playing around with it. If there's any questions you guys forgot or didn't want to ask, call the office, talk to planning and development. My cards are at the back. If you want to shoot me an email, I will forward it on. I am not touching this. I'll give it to the right guys to help you out. As Darcy said, you can get a hold of him at the office, right? Lots of good ways. Lots of great questions tonight. It was very good. Thank you very much for coming.